Welcome everybody. This video is about Anti-SLAPP law modernized, the Uniform Public Expression Protection Act, which is known as the UPEPA. I am your host, Jay Adkisson, and I am the person who proposed the UPEPA to the Uniform Law Commission. Then, I was an American Bar Association Business Law Section Advisor to the drafting committee of the UPEPA. After the UPEPA had been drafted, I wrote a book about it, which bears the same name as the title of this video. First, let's define the problem. The problem is something known as a strategic lawsuit against public participation. I know that's a terrible acronym, but that's known as a SLAPP lawsuit. This is a lawsuit brought to keep a person from exercising their rights to freedom of speech and freedom of petition. A SLAPP lawsuit uses meritless litigation to either attempt to silence somebody or retaliate against them for expressing their opinion. The goal is to punish a person through the mental harassment and the heavy expenses of the litigation itself, even if it is not ultimately successful. An example is an online reviewer who criticizes a company's products. The reviews are either factual or the reviewer's opinion and thus are protected speech. Nonetheless, the company sues the reviewer for defamation and demands that she not review any more of the company's products. The solution to these SLAPP lawsuits is, you guessed it, anti-SLAPP laws. Anti-SLAPP laws force the courts to determine at the outset whether certain lawsuits have merit. Effectively, anti-SLAPP laws move summary judgment, which is ordinarily heard toward the end of the case and right before trial, to the very front of the case. This allows the intervening litigation to be avoided. In addition to facilitating an early dismissal of meritless litigation, anti-SLAPP laws also do some other things. Anti-SLAPP laws make the defendant whole by an automatic award of attorney fees and costs if the defendant wins. The early dismissal and award of attorney fees and costs creates a substantial deterrence for SLAPP suits to be brought in the first place. What makes the UPEPA better than other anti-SLAPP laws is its uniformity provision in Section 12. Uniformity means that the courts of the jurisdictions which have adopted the UPEPA are to strive to make their rulings as similar as possible. This prevents forum shopping between jurisdictions where abusive litigants search for the laws that are the least protective of free speech, what is known as libel tourism. Because of its complex-sounding name, anti-SLAPP laws are often intimidating to lawyers who are not familiar with the procedure. It is actually not that complicated at all. A special motion brought under the UPEPA may be characterized as a pre-discovery motion for summary judgment, or, if you prefer, a motion to dismiss on steroids. If you are familiar with summary judgments and motions to dismiss, the UPEPA special motion will not be difficult at all. Before we get too deep into this, a quick word about two of the terms. The party who is defending against the challenge cause of action is known as the movant because they are the party who brings a special motion to try to get rid of the SLAPP litigation. The party filing the challenge cause of action, the SLAPP litigation, and who is usually the plaintiff in the case is known as the respondent because they are responding to the special motion. The first consideration is whether the cause of action is subject to the UPEPA at all. This is known as being within the scope of the Act. Basically, there are two categories within the scope. First are communications within the context of a governmental proceeding. Second are the exercise of free speech and related rights. Once a cause of action has been filed that falls within the scope of the UPEPA's protections, the movant then has 60 days from the date of that filing to bring a special motion. This is 60 days from the first filing of that cause of action. If there is a pleading amendment, there is no new 60-day protection if the cause of action was pled in a prior pleading. Recall that a main purpose of anti-SLAPP laws is to keep the movement from being subjected to litigation. Thus, Section 4 of the UPEPA states that when a special motion is filed, a stay goes into effect that brings the rest of the litigation, other than the special motion, to a full stop. If the special motion is denied by the court, then the litigation continues about as if the special motion had never been brought in the first place, unless the movant appeals the denial of the special motion. If the court grants the special motion, the effect is that the challenged cause of action will either be stricken or dismissed, depending on the jurisdiction. The court may also grant the special motion as to only the offending part of a cause of action. This is all found in UPEPA Section 7A. If the special motion is denied, then the movant has an automatic appeal of right under UPEPA Section 9. Note that the movant's filing of an appeal will cause the automatic stay to remain in place during the pendency of the appeal. If the special motion is granted, the respondent has no immediate appeal of right. Instead, the respondent has the normal appeal rights of any litigant. If the dismissal or striking is of the entire case, then the respondent can immediately appeal. If it is only of one cause of action, however, the respondent must ordinarily wait until the end of the entire case to appeal. However, the respondent may attempt to bring an interlocutory appeal subject to the discretion of the appellate court to allow. This is usually attempted by some sort of special appellate writ. That is the 39,000-foot view of the special motion. Now we will take a deeper dive into the mechanics of the special motion. UPEPA Section 7A sets out the mechanics of the special motion. The court is required to conduct an analysis in 3 phases. In each phase, the burden shifts from one party to the other. The first phase is that of whether the cause of action falls within the scope of the UPEPA. The burden of showing this is on the movant. If the movant fails to meet the burden of demonstrating that the cause of action falls within the scope of the act, then the special motion should be denied. The litigation then proceeds as if the special motion had never been brought in the first place, unless the movant appeals. On the other hand, if the movant can show that the cause of action is within the scope of the UPEPA, then the burden passes to the respondent to show factual sufficiency, which is Phase 2. Phase 2 measures factual sufficiency, which really means that the respondent can plead a cause of action that can survive dismissal. If the respondent cannot prove this, then the special motion will be granted and the cause of action will be dismissed or stricken. However, if the respondent can prove factual sufficiency, then the burden passes back to the movant to prove that, despite whatever the respondent has pled, the cause of action is not legally sufficient, which is Phase 3. Legal sufficiency tests whether there is minimally enough evidence that the cause of action could properly go to a jury, which is the exact same standard as used for summary judgment. The burden is on the movant to show that there is not enough record evidence for the cause of action to be able to be the basis of a judgment in favor of the respondent. Note that the UPEPA special motion is handled about the same way as a summary judgment motion, but only with the added test of scope and an extra burden shift. Now we turn to some of the more practical aspects of the special motion, being on the proof that the court may consider. The court may take into account the parties' pleadings and any exhibits attached to those pleadings. The court may also take into account any exhibits that are attached to the parties' briefing documents for the special motion. The court may consider any other evidence that would ordinarily be considered on a summary judgment motion as well. We will now do a deeper dive into each of the 3 phases of analysis. As mentioned, the first phase is scope, which is also known as applicability. Does the act apply? Does the cause of action fall within the scope of the UPEPA's protections? The burden at this stage is on the movant, being the party bringing the UPEPA special motion. There are 2 broad categories of things that are included within the scope of the UPEPA's protections. First, the cause of action infringes upon the movant's exercise of their constitutional rights to free speech, rights of the press, to assemble, and to petition the government for redress. Second, the cause of action is about communications relating to a governmental proceeding of any sort. There are also statutory exclusions from scope, meaning that these things are not within the ambit of the UPEPA's protections. The first is where the cause of action is against a governmental entity. The second is that the government cannot bring a special motion unless there is some imminent threat to public health or safety. Third, where the cause of action arises out of communications relating to some commercial activity. If the movement cannot prove that the cause of action falls within the UPEPA scope, then the special motion will be denied. However, if the movement can prove that the cause of action falls within the UPEPA scope, then the court will pass to the next phase of the analysis along with the burden. The second phase is known as factual sufficiency, or sometimes prima facie validity. This element tests whether the cause of action has pled a viable legal theory of relief. The court at this stage is looking at nothing but the pleadings of the respondent, not the evidence. The issue here is purely one of law. In essence, the respondent must show that the cause of action can survive constitutional and other protections for the speech or conduct. What this usually means is that the respondent must show that the cause of action, as it has been pled, can overcome First Amendment protections. If the cause of action does not state a legally viable cause of action, then the special motion will be granted. However, if the respondent can show that the cause of action states a legally viable theory of relief, even in the face of constitutional protections, then the court's analysis proceeds to the third phase, and the burden will also shift back to the movement. The third and last phase in the court's analysis of the special motion is known as legal sufficiency. This means that there is at least a minimum amount of evidence supporting the respondent's cause of action such that the cause of action could properly be sent to the jury. Here, the court is looking at the evidentiary exhibits attached to the respondent's pleadings and to the briefs submitted by both parties. Critically, the court is not weighing the evidence, but must instead look at the evidence only in the light most favorable to the respondent. This is also the same as on a motion for summary judgment. Note that the last two elements, being factual sufficiency and legal sufficiency, are exactly the same two elements as would arise on a motion for summary judgment. This is why a UPEPA special motion can be called an early summary judgment motion, and that would be substantially accurate. An alternative characterization of the UPEPA special motion would be as a Rule 12b-6 motion to dismiss on steroids, since it is not a defense to the motion that discovery has not yet been conducted. If the movement can prove that there has not been enough evidence presented to get the case to a jury, then the special motion will be granted. Conversely, if the movement cannot prove that there is a lack of minimal evidence to get the case to the jury, the special motion will be denied. It is very important to note that the motivation of the respondent, the party bringing the cause of action, is not relevant in the consideration of a UPEPA special motion. There are two reasons for this. The first being that such motivation really doesn't matter, the only important thing being whether the cause of action can survive the challenge. The second reason for this is that the motivation of the respondent would very likely require discovery, and that would defeat a primary purpose of the UPEPA special motion to avoid the cost and expense of discovery. Section 4 of the UPEPA provides for an automatic stay to go into effect upon the filing of the special motion. The automatic stay effectively stops all the litigation between the respondent and movement until the special motion has been decided by the court. The movement, and only the movement, may expand the stay to include other issues that are under consideration by the special motion, such as discovery being made in the case by other parties not involved in the special motion. The UPEPA also provides that a court may not grant relief from the stay between the respondent and the movement, except in cases of an imminent threat to public health or safety. A party to the special motion may move the court to exercise its discretion to allow limited discovery in spite of the limited stay. However, this discovery is strictly limited to evidence that a party proves will be necessary to show that a burden has been met or not met when the special motion is heard. Moreover, this evidence must not be reasonably available from any other source. If the movement wins a special motion, the UPEPA provides for a mandatory award of attorney fees, court costs, and litigation expenses. This would also include any expert witness fees. However, the court has the discretion to award only those fees, costs, and expenses which are reasonable under the circumstances. The respondent is not automatically entitled to fees, costs, and expenses if the respondent wins a special motion. Nonetheless, the court has the discretion to make such an award to the respondent if the court finds that the special motion was frivolous, meaning lacking any real merit, or was filed by the movement solely with the intent to delay the proceeding. Also note that attorney fees might still be awarded to the respondent at the end of the case if the respondent is ultimately successful at trial and the case is one in which attorney fees are awardable. A very important provision of the UPEPA is the construction clause. This clause, found in Section 11, requires the court to interpret the UPEPA in favor of protecting the movement's rights that are identified in the scope of the Act. Now we come to the deadline for things to be done under the UPEPA, but note that the state legislatures, in adopting the UPEPA, will often modify these deadlines. The movement must bring the special motion to strike within 60 days of the date that the infringing cause of action was first pled. Note that a later amendment to the cause of action does not cause a new 60-day period to arise. After the special motion has been filed, the court then has 60 days within which to hear the motion. After the hearing on the motion, the court is required to rule on the motion within 60 days of the hearing. If the special motion is denied, the movement then has 21 days from the date of denial to file an appeal. There is no deadline for the court to set a hearing on or rule upon the movement's entitlement to attorney fees, expenses, and costs. This concludes our overview of the Uniform Public Expression Protection Act. If you enjoyed this video, please like and subscribe. Until next time.